Thank you. So our paper is indeed on the relevance of algorithmic decision predictors for judicial decision making. And I should like to say beforehand that we are discussing only one rather limited specific use of such algorithms, namely as decision support for judges who have to decide individual concrete cases. There may be other uses of such algorithms, other uses within the judiciary or maybe for litigants or legal researchers, but that is not the topic of our paper. Oh, I cannot move to it, yeah. Now, I would like to start with an anecdote. Some 2 years ago, I had to give a talk at a seminar in Utrecht, and another speaker was a Dutch judge. And afterwards, she told me that she expected that soon judges would have to use such predictive algorithms. And then if they deviate in a specific case from a prediction, they would have to explain in their verdict why they deviate from the algorithmic decision prediction. And if they deviate too often in too many cases, they would have a problem. For instance, the president of their court would call them into his or her room. And the underlying idea of constraining judges in this way would be that this would improve the predictability and consistency of judicial decision making. But our question is constraining judges in this way really a good idea? Is this really desirable? And very briefly, our answer will be no, it isn't. And to see this, we should first say a bit more about the assumptions that seem to underlie this way of thinking and this way of wanting to constrain judges. And one idea seems to be that a decision predicted by a good algorithm, good in the sense that it performed well in the test phase, on the test set, would somehow be the normal case decision of the case. That is the decision that any arbitrary competent judge, when assigned to the same case, would probably take. And we take that probability, we call that in our paper the decision probability, so which is a probability that the predicted decision will indeed, in this case that is now to be decided, be taken. And then it seems rational to require that the judge can only deviate from the prediction if he or she can point at special circumstances in the case at hand. If she cannot do that, then the judge should go along with the normal decision. But our claim is that a prediction of an algorithm, a decision prediction combined with the usual performance metrics do not imply such a decision probability for this specific case. A prediction does not tell the judge what their colleagues would likely decide in the same case. And that is the main claim of our paper. Now, we'll explain this in a bit more detail. There are, of course, several quantitative performance criteria that are often used in machine learning and also in AI and law. For instance, accuracy, precision, recall, combinations of that like F1. On this slide, we consider, just for ease of explanation, precision, but our argument is essentially the same for other of the usual performance criteria. Now, suppose an algorithm in a new case predicts that the plaintiff in that case will win, and that in the test phase, 85% of the predictions of this algorithm were correct, so they came true. Now, as is well known in the literature, good performance in the past on test cases does not automatically imply also good performance in the future on other cases that arise. For instance, the training and test cases may not be representative of the domain. Some of, or even many of the decisions may be legally incorrect, or at least legally dubious. They may be outdated because judges have changed their practice, the way of deciding, or more technical issue, the learned model may be overfitted to the particulars of the data in the training set. But let us, just for the sake of argument, assume that these problems do not arise. This is a big assumption, which will often not be satisfied. But anyway, our main argument is about cases where these other problems do not arise. And can we then say of this algorithm and this prediction that indeed the probability that plaintiff will win is 85%? And our answer is no, we cannot say that. And I will explain that with an analogy with a well-known example from textbooks in statistics and probability theory. Someone fills an urn with 85 red balls and 15 blue balls, and then we take a ball from the top and ask what is the probability that the ball is red. I think many, if not all of you, will say that's 85%. And I think that's a rational answer in this case. But suppose now that the guy who filled the urn tells you, well, I first put all red balls and then all the blue balls in the urn and I didn't stir. And then you should ask, what is then the probability that the ball that you took from the top is red? I think many of you will now say, well, this probability is much lower than 85%, maybe even lower than 15%, because you now have extra information that is also relevant. Now, to make the analogy, replace the red balls with the case that the prediction of the algorithm was correct, and the blue balls with cases where the prediction was incorrect, 85% and 15%. And what we have here is what philosophers call the problem of the reference class. And this is the problem that the step from frequency information about classes of events or individuals to an individual probability about a specific event or individual, this step is not automatic. There is a logical gap between the two. And in fact, philosophers have explained that applying a frequency statistical probability to an individual case in fact expresses a relevance judgment. It says that the only things that are relevant to the case at hand are what is stated in the frequency. So in the urn example, the only thing that is relevant would be relevant with the 85% frequency would be how many red and blue balls are there in the urn. And in our case, judicial decision making, the only thing that would be relevant is actually what is in the confusion matrix, so information about how many predictions came true and similar information. But just as in the urn example, this relevance judges, well, actually, there is more relevant information, namely the guy, how the balls got into the urn. In a legal case, there is, of course, actually always more information because the judge always knows all the facts of the case. So the frequency that you could say is based on the numerical performance information is simply not applicable anymore to the case. It doesn't tell what an arbitrary judge in the same case would probably decide. So that is the core of our argument in the paper. Now, what does that mean for practice? We recommend, and I should say I'm a little bit more strict here than Flores, who is a bit more moderate, but anyway, we think that judges should only consult algorithmic decision predictors that can explain their prediction in legal terms by giving a legal argument. And then, this is my bit, they should only look at the explanation. They should not consider the numerical performance information, because doing so can be misleading, because again, it doesn't tell the judge what an arbitrary judge in the case would probably decide. It doesn't tell that this is the normal decision that the judge should take, and that the judge can only deviate if he or she can find special circumstances in the case. So going back to the Dutch judge, this idea of constraining the judge in this way by algorithmic decision prediction is not a good idea. It will not promote the predictability and consistency of legal decision making in desirable ways. So my last slide. Now, since the explanation for the prediction is so important, the legal reasons given for it, we also think that evaluating the quality of these algorithmic decision predictors should happen in a different way. We should focus less on these numerical performance criteria like accuracy and so on, and more on, yeah, maybe more old-fashioned qualitative evaluation methods where we maybe have human users who kind of give us insight into the usefulness or at least understandability of the explanations, and human evaluators that can who can evaluate the quality of the legal arguments given. Okay, that was it. I thank you for your attention.
Thanks, Professor Henry. Uh, we have one question already, but I'd like also to make a question from myself. Uh, oh, you just said that judges should only accept uh, algorithm recommendations uh, if the algorithm could justify its recommendation by legal reasoning, legal arguments. Um, for this to happen properly, uh, we should allow only the use of open source algorithms because if we use algorithms made by companies like in United States, for example, uh, we have a problem uh, for know the criteria that algorithm use to make the recommendation. What do you think about that?
Well, that is another important issue, of course, with the practical use of such algorithms, but that was not the topic of our paper, actually. So I'm not sure if I can say much about that now. By the way, I should say we don't claim that judges should always accept the predictions when they are accompanied by a legal argument. You should look more at such algorithms as, well, giving peer advice. So it's such as in the same way as we, maybe judges, ask their colleague judges, what do you think of this case? And then they can discuss it with each other, but the deciding judge always has to consider the value of the advice of his or her colleague on its own merit. So we don't even claim that this kind of predictive algorithm that can explain its predictions should by default be followed by judges. It's more a kind of, yeah, useful information source to consult, but in the end, the judge should perform their own thinking about the case. The other topic would be a topic of a new paper, I think.
Okay, thanks, Professor. And we have other questions also. The first one from Michael, I think. Uh, if a judge deviates from a well-established line of judicial opinions or earlier case law, this deviation should be properly justified. Of course, algorithmic prediction is something else than a well-established line of earlier case law. However, let us assume that the algorithm prediction is adequately explained via some argumentation system, and this argumentation is sound. In such situation, shouldn't we expect the judge to justify the deviation from the explanation representing prediction?
Well, the key issue here, of course, is how do we know that the argumentation of the system is sound? Uh, in the end, the judge who gets this advice from the algorithm has to assess the quality of the argumentation. Uh, but partly this can be done in the evaluation phase. This was the recommendation on my final slide, just like maybe the famous evaluation of the Mycin expert system in the 1970s, where the quality of the medical diagnosis and treatment advice was assessed by senior medical human experts. You could do the same with a predictive algorithm, and then you could have some information about the general quality of the advice given by this algorithm. But even then, it is in the end the judge's task in the case to assess the quality of the argumentation given by the system. We don't know. It doesn't come labeled as sound to us.
Okay. A third question here is from Bart Verheij. Can you relate your position to the claim by Towin and Pollock that probabilistic reasoning is not enough and that a form of the feasible argument is needed?
Yes, I think this pertains to the philosophical problem of the reference class, and Bart knows just as well as me that in the early days of non-monotonic logic, several researchers indeed proposed forms of non-monotonic logic as a way to deal with the reference class problem. For instance, Ron Louis, who some of us still know, said this was in the end an application of the specificity principle in comparing and choosing between conflicting arguments based on conflicting statistical generalizations. So yes, this is my answer to Bart.
Okay. We have also a question by Elton McCarty. Your argument from the earned knowledge is that the judge always know more about the case than the simple numerical prediction. But if the issue is whether a judge should explain a deviation from the numerical prediction, wouldn't it be consistent with your argument to expect the judge to explain what is about the case that is distinctive? Being a, he says that he's been a devil's advocate here.
No, it's a very interesting question. I hope I understand it correctly. I mean, I think, as I understand the word distinctive, but I'm not a native English speaker, this is what judges always have to do. They always have to say are the essential grounds and essential facts in the case that supports their decision. That is what my answer is. I mean, the judge simply has to consider all the facts of the case and then give the justification for their decision. There is no sense of comparing this, I think, meaningful sense in which the judge can do that with comparing it with the algorithm's prediction, maybe with the algorithm's argument, but that is that could be done, that the judge at some point gets the obligation to say something about the argument given by a good algorithmic decision predictor. Do I see it correctly that my co-author is now asking a question to me?
I think he is making a comment.
Okay.
His comment is, I guess, that even if I think he's making a comment, not a question.
Flores is not in the room, I see.
Well, we have another question. I think is the last one. A very common problem with the use of predictors of court decisions by judges is causing the stagnation of case law. How can this be avoided with algorithms?
Who is asking that? Yeah.
I don't have the name
No,
of
it's
the person.
It's a big issue. It's an often discussed issue in the literature, and I don't have a clear answer to it. I don't think I have to have an answer to it because I'm not a person who is developing such algorithms and recommending their use in court. So yeah, it's a big problem, I think.
Okay, and this was the last question, and unfortunately, by constraint of time, we have to go to the fourth presentation, and Thank you, Professor Henry Prakken. It was a pleasure to hear you.